All rise to the jury. You may be seated, please. Okay, you've heard all the evidence that you're going to hear in this phase. We're now moving to the closing arguments of the counsel. Again, the state, because they do have the burden, have two opportunities. So on behalf of the state.
Thank you, sorry, we might have forgot the clicker, so I'm going to be the clicker. No, that was Dr.
Oh.
Thank you. Good afternoon. That was weak. It's been a long day, you guys, I know. But here we are, right? We're at the hard part that we talked about so many weeks ago. And again, I don't want you to think that we think this isn't hard. It's hard to hear somebody, like a real life person, talk to you, right, and make this decision. And so I don't want any of what we're saying today or throughout all of this to somehow lessen that for you all. And I don't want you to think that we think it's not a big deal. But what we do think is that we have proven to you beyond a reasonable doubt that those aggravating circumstances outweigh the mitigating factors beyond a reasonable doubt. I want to walk through them with you again, very briefly, okay? So you know here you have 5 different aggravating circumstances. You have this first one, okay, that the judge heard, that you guys did not hear in the first phase, but now you did hear just yesterday. And one of those specifications, or this first specification, is that he, prior to this offense, was convicted of an offense that involves the purposeful killing of, or in this case, an attempt to kill another person. That's what put him with the big boys, ladies and gentlemen. When you try to kill somebody, you go to prison, okay? So that's specification number 1. And I'll let you know that this is for each and every one of those aggravated murder counts. So just like you had different theories or different ways the aggravated murder was committed, you have to render a verdict on all of them. Okay, so you're going to go back there and be deciding this weighing process on each of those aggravated murder charges. And the specifications are the same. So don't worry, I'm not going to go through them 5 times for all the counts or 4 times. Okay? The next specification is that he committed the offense while he was committing the aggravated burglary. Okay? So you all remember that part of it. So that's specification 2. So while he is committing that aggravated burglary, he causes her death. The third specification is that he committed the murder, or the aggravated murder really, while committing the offense of kidnapping. Okay, you heard all of the evidence about that, and we cannot sit here and argue all the facts of the case to you because that's not appropriate. Only the circumstances that are aggravating are appropriate to consider. But we ask you to consider this part of it. The kidnapping. Think about the kidnapping that took place with Rachel and how she died during that kidnapping. The next specification is that the homicide took place either while he committed a rape or while he's fleeing after the rape or something along those lines, right? So the rape is an aggravating circumstance. The next aggravating circumstance is that he committed the offense while committing or attempting to commit the aggravated robbery. And you'll notice on each of those, and you saw it in the jury instructions, that he personally committed each act that constituted the aggravated murder. That just means he was alone, right? Mr. O'Brien told you that yesterday. He wasn't the getaway driver. He was the actual person that committed the actual homicide. Okay? So that is one of your other aggravating circumstances. I'm going to remind you, that is 5 aggravating circumstances. How many make you eligible for the death penalty? 1. Any one of those is enough under the law for us to be here in this courtroom. 1. You don't have 1. You don't have 2. You don't have 3. You don't even, it's not even, we're not even going to stop at 4. You have 5 aggravating circumstances to put on that side of the scale that we talked about during voir dire. You also heard about mitigating factors, and the judge is going to go through those more with you, but if you recall, If you were one of the groups I talked to, I think the way I talked about it was, how did we get here? Which is basically what Dr. Stinson told you, right? How did he get to this point sitting at this table in front of you? And those are the things you're going to put on the other side of the scale, right? Here's one thing you do have to do. So while you cannot consider the nature and the circumstances of the crime as an aggravating circumstance, so you can't consider the facts that don't relate to the aggravating circumstances, if that makes sense, you are supposed to take a look at them and determine if there is anything mitigating about what happened to Rachel. And I would suggest to you that there is absolutely nothing mitigating. There are no mitigating factors as to the nature and the circumstances. Nothing mitigates the facts and the circumstances, the nature and the circumstances of the offense. There's nothing mitigating in there. You heard a lot about the history, the character, and the background of the defendant. One of the other ones to consider, these are just part of the list, whether or not he lacked the ability to appreciate his conduct, and any other factors. So that's kind of a catch-all. So really, we have this, in true lawyer fashion, we have a long list and then one that says, you know, anything else you want to consider. Okay? So really, anything that you think deserves weight on that side of it that is mitigating. That's the important thing. That's mitigating, right? So, this is where we get to the scale. We were tired of talking about that scale by the end of talking to you guys, right? But the scale is what's so important. Because remember, we talked a lot about, we want to make sure you don't put your thumb on one side or the other, because now you're here. Here we are, and this is that hard job we're asking you to do. So remember, those aggravating circumstances, all 5, go on one side of the scale. We have proven those to you beyond a reasonable doubt. You already found him guilty of them. Okay? And now we engage in this weighing process. So you put them on the scale, and how heavy they are is up to you. We would submit to you that, remember, 1 is enough. 5 is really heavy. Okay? And then what you're going to do is you're going to take the things that you heard yesterday and today and put them on the other side, those mitigating factors. And you're going to assign whatever weight to them that you deem fit. I will not stand up here and suggest to you that you should give them 0 weight. I would imagine that some of the things you heard probably resonated with you, right? It's not hard to imagine a young child being beaten and feeling bad for that young child. I'll acknowledge that to you. But that young child is not sitting at the table right now. Okay, we're a long way from there. And I want to talk a little bit more about that with you. But you can assign any amount of weight to those mitigating factors that you deem appropriate. You could give them very little weight. You could give them a lot. But I would submit to you that no matter the weight you give, they will not reach the point where we're even with the aggravating circumstances or that they outweigh. I'll also remind you that you all need to be unanimous as to your verdict with regard to the death penalty. But if you remember, when I was talking, at least if I got to talk to you guys, we talked about you don't have to be unanimous as to the amount of the outweighing, right? Somebody could think that the aggravating circumstances outweigh the mitigating factors by just a little bit. And somebody could say they're all the way on the floor, Ms. Roush. As long as you all agree that the aggravating circumstances outweigh the mitigating factors beyond a reasonable doubt, then the only verdict under the law is death. And that is a hard job. But I want to talk about the things that we're going to put on the other side of the scale, right? The mitigating factors. Because you've heard a lot about them. Let's talk a little bit about the things that Dr. Stinson told you guys. If you noticed, and I don't have the chart, may I borrow that? So if you remember, we have the chart, right, that had the ACEs, the adverse childhood experiences. And the way that I recall Dr. Stinson's testimony, now again, same as in the first phase. If you heard something different than I'm telling you, the way I heard it, you rely on your memories. I'm not trying to trick you. But we have these different kinds of things that are adverse childhood experiences. And if you recall, he went through a long list of things before that. And then said, plus these 9 adverse childhood experiences. I would suggest to you that he was doubling up some of that information. Because the beginning of that list included things like, if I recall on his slides, his abusive father. We had bullet points, and at the bottom was adverse childhood experiences. Well, the first bullet point was an abusive father. Okay? An abusive father falls under this ACE. Okay? So it's not all of these things plus 9 ACEs. He has 7 of the 9, 9 of the 10. He was doubling up his numbers. Neglectful mother, that falls under this other ACE as well. Family mental health, drug and alcohol problems, family legal problems, under household dysfunction. So Dr. Stinson listed all of those separately and then said ACEs, plus 9 ACEs. And then he said all these things over and over and over again, okay? Again, I'm not suggesting that you can't give that any weight. I'm suggesting that that should factor in how much weight you give that information. The fact that it was repeated, just because I say it multiple times doesn't make it more true, right? Ask my kid. I'd ask you also to think about your friends, your family, maybe some of you. Maybe some of you are fortunate enough to have 0, like me. Maybe some of you are not as fortunate as me. Maybe some of you live with somebody that has, I don't know, 7 ACEs, like me. It's not my son. I didn't give my son 7 ACEs. Okay? Maybe some of you have a spouse that has 7 ACEs, like me. Do you know who's not sitting there? My spouse. He hasn't killed me yet. Okay? I'm not trying to be flip. My point is that the ACEs are helpful, but they don't necessarily put you at that table. Lots of people have these childhood experiences and they overcome them. And they are able to deal with them, and they are able, most importantly, yes, they might have terrible lives, they might commit crimes, but they don't commit this crime. Who's sitting at that table? Not any of the other pardon kids. You heard about them having financial crimes, fraud. You didn't hear about any other capital cases that his siblings have, that his mother has. So again, I'm not suggesting that those aren't things for you to consider. I'm suggesting that you should consider what I'm telling you when you assign the weight to those mitigating factors. And those are some of the reasons that the state thinks that those mitigating factors do not get as much weight as the aggravating circumstances. You also heard a lot about systemic failure. I'm sure prison is terrible. But again, when you attempt to murder someone, you end up in prison. And when you have 17 infractions in 1 year, you go to a higher security level. That happens. And when you refuse counseling, or you won't meet with people, or you continue to have infraction after infraction after infraction, at some point, ladies and gentlemen, you can lead the horse to water, but you can't make him drink. At some point, it is not the prison's fault. You did not hear any testimony that he signed up for every program. You heard he did 1. This is not somebody that signed up for everything he possibly could. This is not somebody that followed all the rules and did the best that he could in prison to get out at 5 years. He did all of his time because he was awful in prison. He continued to exhibit the violent behavior that he had exhibited since he was a teenager and that he exhibited the second he got out of Georgia prison and came here and committed these offenses. And at some point, that is not our fault, as he suggested. That is not your fault. That is not my fault. That is not the system's fault. That is his fault. And again, I'm not suggesting that you shouldn't consider the information you heard. But what I'm suggesting to you is to not lose sight of what you heard that were those aggravating circumstances. Again, not 1, not 2, but 5. And it is our position that those 5 aggravating circumstances outweigh those mitigating factors beyond a reasonable doubt. And the only appropriate sentence here is death. Thank you.
Thank you, Ms. Rouse.